right, let's go ahead and start. Let's put phones away. Anyone have any questions about paper number 3? Raise your column.
Does it have to be concrete, like change, or can it be like kind of a change in the way, like the court?
So the prompt asks you to write about constitutional change. Yeah, let me find it. So, identify some significant way in which the Constitution has changed during your lifetime. Now, at first glance, on one particular way of thinking about that, you might say the Constitution has not changed at all during my lifetime because no amendments have been enacted during most of your lifetimes. There have been 2 amendments enacted during my lifetime. So in terms of literal changes to the constitutional text, the answer is probably not very much has happened, and so that would be a short paper, right? So, okay, so what else does it mean? And then the prompt goes on, with a lot of additional detail. So as we have seen throughout some of our discussions this semester, it is sometimes the case that though the words of the constitutional text stay the same, our understanding of them shifts. And so that's the kind of constitutional change that I'm asking you to look for. Raise your hand if you have some idea of what you're writing about in that paper already. Okay, keep your hand up if you will tell me right now what that some idea is. Yeah.
Just kind of like the changes in judicial conservatism, like how it's kind of evolved these past 10 so years.
Did you have any examples in mind yet?
Yes, so mine was Citizens United versus WC.
Okay.
That's like the main one I have.
That's a good start. So, one thing I said last time is, if you don't have a starting place yet, one useful starting place is the syllabus, right? So flip ahead to all our remaining weeks and look at the different topics that we're covering and see which of those seem interesting to you. Another way of starting is with something that you already know about, like from the news or from talking to people, right? Oh, here's some significant constitutional thing that seems to have happened in recent years. I'm interested in that. I want to understand how that came about, how we got to that. And so Citizens United versus FEC is a pretty well-known Supreme Court case from 2010, which we will talk about. But that's a good starting point, right? So that's like, all right, let me go read something about Citizens United versus FEC, understand what happened, and then try to connect that backwards, working backwards, connect that to some patterns of change that led up to that, right? How did we get to the court issue in Citizens United versus FEC? So that's another good way to get started. All right, who else had a hand up so that you might know what you're writing about a little bit? Yeah, Brian?
I was going to say changes in how people are interpreting the Second Amendment, like Heller and Mick.
Yep, that's a good one.
Chicago.
Yep, Heller and McDonald. Yep, two good cases. Maurice?
This is actually a question because I think the change started happening before I was born.
That's
but
okay.
The change in how affirmative action is now used to promote diversity instead of right the wrongs of segregation. Yeah,
so that's fine. It could be if you think about how change occurs over time, right? Say we were talking about the growth of presidential power. It might look sort of like that, or maybe it might look like that or something, right? That over time there's been a consistent trend, like that's a 200-year trend line, right? So I don't want, but if this part is your lifetime and it has still continued to change, or even if it's not a 200-year trend, but it's a 40-year trend, and you have only been alive for 20 of those years, that's fine. You can definitely write about that. And you can for sure talk in the paper about things that happened before you were born in order to illustrate the changes that you're trying to demonstrate, right? Like you might have to spend some time in the paper, depending on what you're writing about. You might have to spend some time talking about something that happened during the Warren Court, right? If the current court is doing something very differently than the Warren Court did it, then in order to show that change, you might have to spend some time saying, well, here's what the court at once upon a time, here's how they interpreted the Second Amendment, and here's how the court today is interpreting the Second Amendment, right? So you can definitely talk about stuff that happened before you were born, either as like a counterpoint to show the change, or as showing like the beginnings of the trend that started before you were born. That's fine. You know. Who else had anything? Yeah.
How much time should we spend on this precedence if we choose to do that?
I don't want to give a cookie cutter answer. The goal of the ultimate 10-page paper, the thematic focus of it, is on constitutional changes during your lifetime. So a substantial portion of it should be devoted to constitutional changes during your lifetime. But depending upon what you are writing about, it might make sense to spend a good amount of space on kind of setting that up with stuff that happened before you were born. Somewhat trickier to answer even is what should be in the 4-page partial draft, right? Sometimes with this assignment, the way some students think about it, and they come talk to me and they show me a draft, is they're like, well, I'm writing the first 4 pages. I'm writing a 10-page paper in order, and so I'm giving you the first 4 pages. That is not an unreasonable way to think about it. But if your first 4 pages are all like historical setup that don't actually include anything about something that happened during your lifetime, then that doesn't give us a lot to go on in terms of, like, you got to give us something, even in the 4-page version. That can't be all just precursors, right? You got to give us something that happened in your lifetime. And so if the way you are envisioning, as you get rolling, if the way you are envisioning the 10-page paper is that several pages at the beginning survey developments that happened before you were born, and then you're going to show how they changed over the past 20 years, if that's the way you're envisioning it, then you might not want to write the 10 pages in order, right? The 4 pages might want to be like an introductory section, which gives a somewhat, provisional account of what your thesis and your argument is going to be. Then like a header that says, developments during the Warren Court era, where you just write, here I'm going to survey the following developments, but you skip that part for now, and then you write us a couple pages analyzing at least one significant part of what's happened during your lifetime. That would give us more to go on in evaluating the partial draft.
So the partial draft that we're submitting doesn't need to follow like standard essay formatting. It's okay if we put in like a header, like, okay, information is supposed to be here.
Yeah, I always, so the answer to that question is yes. It does not need to follow standard essay formatting. However, it does need to be written in sentences and paragraphs. Like for the 1-pager that we got initially for the Warren Court, like some people basically just gave us an outline, like list of bullet points, which is not what I wanted, right? I wanted paragraphs, right? And so as long as there are some well-crafted paragraphs on some of those 4 pages, it is okay if there are also some things in brackets or bullets or whatever that say, here I'm planning to insert an analysis of the Warren Court's right to counsel decisions, and then you skip that for now, and then you have some initial paragraphs analyzing some recent right to counsel decisions, right? So yes, that is fine, as long as there are some actually crafted paragraphs in the 4 pages. It is fine if part of the 4 pages gesture at some sections that are not yet written. That's fine. Other questions? Anybody else want to tell us what you're writing about? You got a starting point so far. It's the last time I'm going to see you for a little while. I got office hours right after class, but if you don't come then, today is the last time I'm going to see you for a while. I'm available by email over spring break, if needed. Okay. So again, if you do not yet have any clue what you're writing about, that is fine, as long as you start to move in the direction of getting a clue soon. And the 2 places to look for a clue are flip through the second half of the syllabus, right? Look at all the topics we're covering, and or like think about, have some conversations with people about recent or current events that have something to do with the Constitution. I don't want a 10-page paper that is solely about things that are in like today's headlines, but things that are in today's headlines could for sure be a starting point for a paper that you then have to trace back and connect to some things. Like, how did we get to this point where here's the way we're currently thinking about the Constitution? Okay. Okay, so one actual item from the headlines this week that's relevant to today's lecture. The Supreme Court earlier this week agreed to hear a case called Gundy versus United States. So at this point in the court's schedule, right, so the court's term starts in October every year, and up through around now, like the middle of March, sometimes up to the end of March, the court keeps hearing arguments in cases, and then they stop. They stop hearing arguments in cases in order to give themselves time to decide all of the cases and write all the opinions in the cases that they've heard arguments in. And then by the end of June, they decide all the cases that they've heard arguments in. They've already decided some cases, right? They issue decisions as they go, but they all come out by the end of June. Then they go on vacation for 3 months, and they come back in October. And so right now, when they are agreeing to hear a case, that means it's a case that's going to be heard next year, right? So we don't have any decision anytime soon in this case. The court has just agreed to hear this case, called Gundy versus the United States. It's not the kind of case that is going to draw tons of public attention, but it is a case that is potentially very significant constitutionally, depending what they do, what they say in it. And it's a case that lawyers and judges and Supreme Court junkies are going to pay a lot of attention to. And it just coincidentally happens to be directly relevant to what we were going to talk about today. Yeah.
How do you like the name of the case? What was it?
Gundy versus United States. It's on the handout under Roman numeral 1. It is about a convicted sex offender. There's a federal law that says people who have been convicted of rape, sexual assault, etc., after they are released from prison, right, have to register with the government, right, so that their names and addresses can be publicly posted, so that folks who do not want to live near a convicted sex offender, or at least want to know about any convicted sex offenders that are in the neighborhood, can access that information. And when Congress passed that law, which was, when was it? I think it was during the Bush administration, maybe 2005, something around then. When Congress passed that law, it said it applies, the registration requirements apply to all future convictions. So starting today, anybody who gets convicted of sexual assault, once they're released from prison, they have to follow these registration requirements. In addition, we delegate to the Attorney General authority to decide whether and how these registration requirements should apply to past convictions, right? So somebody who 5 years ago was convicted of rape, then the law is passed today, and then next year they are released from prison, right? Should the same registration requirements apply to them or not? We're going to delegate that to the Attorney General to come up with some regulations on how that should work. This guy was convicted of rape prior to the laws being enacted. He was then released from prison, and he then moved from one state to another, and the law says every time you move across state lines, you have to re-register, and he didn't register. And there's a whole bunch of technical legal issues about the facts of his particular case, like whether the law actually applied, whether he had actually moved across state lines, whether the law actually applied to this kind of circumstance. The court said we're not interested in any of those. We're not focused on those factual details in the case. We do, however, agree to hear the case, to focus on one question, and the court often does this when they agree to hear a case. They say, here's the legal question we want the lawyers to focus on. And the question is whether Congress unlawfully delegated legislative authority to the Attorney General, which raises a constitutional issue known as the non-delegation doctrine. the non-delegation doctrine is, right, those words are not in the Constitution, right? It is a set of legal ideas invented by lawyers and judges that are drawn from the Constitution that say only Congress is allowed to exercise legislative power. It's not allowed to delegate its legislative power to some other part of the government. And in Con Law 1, we talked about a case in which the court struck down a law under this doctrine. It was Schechter versus United States in 1935, which scholars sometimes refer to as the sick chicken case, because it was about a poultry company and it was partly about health regulations applied to poultry companies. And it was during the New Deal, and it was one of the most significant laws passed by FDR in his first term, in his first 100 days in office, called the National Industrial Recovery Act, which said in order to get us out of the Great Depression, we are going to appoint like an industry board for each of the following industries that's going to consist of representatives of key corporations, representatives of labor unions, some other folks, experts appointed by government, and that board is going to have the authority to establish specific rules and regulations that apply to that industry, including minimum wages, if they think that would be helpful, including the regulations of hours and working conditions, whatever regulations they conclude would help prop up the success of that industry and help it survive through the Great Depression. They could impose those rules. Court struck that law down. Said it violates the non-delegation doctrine. Congress is delegating its legislative power to somebody else, right? You're going to have a minimum wage law, a minimum wage requirement made up by this board instead of by Congress. That is the last time the Supreme Court has struck down a law under the non-delegation doctrine. And the last time the court considered this issue at any length was a case in 2001 called Whitman versus American Trucking Association, in which the American Trucking Association made this very same argument. I'll tell you what the facts are about in a second. And the court rejected it unanimously. And the fact that the court has agreed to hear this case brought by this convicted sex offender and has already said explicitly that they're not interested in deciding some of the specific legal issues that his lawyers had raised, but they are interested in deciding the non-delegation claim, which is an issue that they ruled on unanimously 17 years ago, is leading some observers to think they might be changing their mind. In the Whitman versus American Trucking case, which I'll tell you about in a second, Justice Clarence Thomas wrote a concurring opinion in which he seemed to suggest that, all right, I'm going along with this here, but I think maybe we need to review our precedents on this matter and go back to the period up until 1935 when we used to take this doctrine seriously. Justice Neil Gorsuch, when he was a lower court judge in Colorado, wrote some opinions saying basically the same thing. Right? I know the Supreme Court doesn't really enforce the non-delegation doctrine anymore, and so I'm not going to enforce it here in this case. However, it seems to me that the doctrine plays an important role, and we have lost sight of its important role, and we should take another look at it. Right? So he seems interested in reconsidering it. Are there 3 other justices on the court who also are interested in reconsidering it? I have no idea. But it would be an enormous change. It's a technical, pretty technical, lawyerly question of constitutional law, but it would be an enormous change if the court returned to the 1930s precedents on this front. And I will tell you why. So the American Trucking case goes like this. The Clean Air Act, which is a major federal environmental law, first enacted in the early 1970s and renewed multiple times since then. The Clean Air Act directs the EPA, the Environmental Protection Agency, to set air quality standards for various pollutants. And now one way Congress could write such a law is Congress could say, here are a list of pollutants here is the concentration in parts per million at which each of these chemicals becomes harmful to human health, right? And so here is the levels at which it is illegal for anybody to emit these pollutants into the air. That is not what Congress does. How the heck would they get, they would spend their entire lifetimes working on that one law, right? Congress doesn't know anything about how many parts per million, like at what parts per million mercury becomes toxic, right? And when new scientific evidence comes out 10 years from now saying actually it's toxic even at smaller levels than we thought, then Congress has to pass a brand new law. That is not how the modern Congress typically works. How the modern Congress typically works since the 1930s is they pass a law that outlines some broad principles. Clean air is important. We would like the air to be cleaner. We would like less pollution in the air, right? We would like, to the extent that is practically and scientifically and technologically and economically feasible, we would like to promote and protect human health by making the air cleaner. That is basically what the Clean Air Act says. And then it delegates to an agency of the federal government that is supposed to be staffed with experts who know what they're talking about on this issue, right? EPA has lots of scientists on staff, usually. It says EPA gets to decide the particular levels for each pollutant, right? And the EPA should periodically review and revise those standards as new scientific information becomes available, right? And the EPA is directed to set the air quality standards at levels that are requisite to protect the public health. That's what the law says. So that law is passed by Congress. It's not like Congress is shirking its legislative powers. Congress is passing a law to address an important public problem, but it is just saying that the specific details of the law should be filled in by a federal agency staffed by experts. The American Trucking Association, right? So there's regulations imposed on trucks, right? Emissions requirements, right? Imposed on the operation of 18-wheelers, as with other motor vehicles. And the American Trucking Association argued that the recent revision of the emission standards as applied to the trucking fleet, by the EPA is unconstitutional because it violates the non-delegation doctrine. Because we got federal laws being made up by these unelected bureaucrats, not by Congress itself. And the Supreme Court ruled against them unanimously. Now, that is not how government worked. Maybe in the 18th century, right? Maybe Congress is going to come up with every federal rule by itself. But in the modern 20th century government, right, the regulatory state that has grown up since the New Deal, right, in which there are a wide array of federal agencies that are responsible for filling out the particular details of federal laws. That's fine, as long as it is Congress that is setting the general principle, giving some guidance to the agencies. It's fine if they are delegating to agencies the authority to fill in the details. The decision was unanimous, although there were several different concurring opinions. The justices did not all agree with each other on what the proper standard actually should be. Two of them said, this is old and outdated. It doesn't even make any sense at all anymore. We should just frankly acknowledge that we have gotten rid of it. We have not used it really since 1935, right? We should just say it doesn't apply anymore. Doesn't exist anymore. That's not part of the Constitution any longer. We should say that explicitly. That's what two of the justices said. Most of them said, the non-delegation doctrine still applies. We want to make sure Congress isn't just giving away its legislative authority. But we're going to apply that pretty loosely, right? As long as Congress is setting out a general standard, it's okay if they're giving somebody else the authority to fill in the details, because there are a wide array of environmental and labor and consumer protection and securities regulation, and so many different kinds of federal laws work this way, right? The SEC comes up with all the specific rules that apply to Wall Street trading, right? Congress sets the general principles of the federal law, But then all the specific rules and regulations that apply to different kinds of derivatives trading and the like, right, those are set by the experts at the SEC, right, not by Congress itself. That is how federal law generally functions nowadays, and that does not raise any constitutional problem, the court said, unanimously, in 2001. The fact that the court has now agreed to revisit this issue, again, we don't know, but like, why are they bothering to hear this case? I don't think they're bothering to hear this case because the justices have some strong and significant concerns about how the federal sex offender registry law is working. That does not seem to be the issue, right? Some of the justices appear to have strong and significant concerns about the non-delegation doctrine, and this case is a vehicle for them to review the doctrine again. Questions about that? Yeah.
How many justices remain from the 2001 court? I don't believe it.
Scalia passed away, so let me think about this for a second. That's 2001, so both of Bush appointees are new, and both of Obama's appointees are new, and Trump's appointee is new. So there are 5 new justices. And of the ones who are still there, we know that Thomas wrote a concurring opinion in that case, where he said again, he's like, I don't think the Trucking Association has enough to win this case here. I'm concurring; it's unanimous. However, I am noting that the non-delegation doctrine plays an important constitutional role, and I think our recent precedents that have not actively enforced that doctrine merit a fresh look. He said something like that, So we know Thomas potentially has questions about it. We know Justice Gorsuch potentially has questions about it. We don't know what Roberts and Alito would say. They have not ruled on it since they've been on the court. That's still not 5. So somebody else would have to change their mind too, in order for them to reverse it. And it's possible that they outright reverse some of these precedents and they fully revive the non-delegation doctrine. It is also possible that they do something kind of cautious at the margins and they say, well, we're not overturning Whitman versus American Trucking, but we do need to tighten this up a little bit. And here, in this particular case, in the Sex Offender Registry Act, Congress has not given adequate guidance to the Attorney General on how he should decide which offenders this applies to and which ones it doesn't. And so this guy's conviction for violating the Registry Act is overturned, and that's not that significant by itself, but then that would lead to lots of subsequent litigation about all these other laws. Oh, maybe the Clean Air Act, or maybe the Clean Water Act, or maybe the securities regulation laws don't provide adequate guidance to the regulators either, and there would be lots of challenges. If the court ruled in that way, there would be lots of subsequent challenges to other federal laws.
So when you say that they want to get rid of the non-delegation doctrine, does that mean that they want a new doctrine? Does it mean that they want less delegation, more delegation?
So the non-delegation doctrine that was in place up until 1935 supposedly says Congress is not allowed to delegate legislative authority at all. Since 1935, the Supreme Court has repeatedly issued decisions that allow Congress to delegate legislative authority as long as Congress is setting the general rules. The court's official position is that the non-delegation doctrine still exists. It's just, if Congress is setting the general rules, we don't think Congress has delegated legislative power. We think Congress is still exercising the legislative power, and it's delegating some subsidiary power to somebody else. And so 2 justices say, that's just a joke. Like, let's just acknowledge that we don't really any longer prohibit Congress from delegating legislative power, right? So we should get rid of it, and there should be no constitutional limits. 2 justices. There should be no constitutional limits on Congress's authority to delegate legislative power. Again, that doesn't mean, like, Congress can, like, pick a king and give him the power to do everything or whatever. Congress still has the legislative power, right? If the EPA enacts regulations that Congress doesn't like, Congress is free to amend the Clean Air Act and get rid of those, say, no, actually, mercury is perfectly safe in our view. Those regulations are rescinded, and mercury's not going to be regulated unless it reaches this level of concentration. Congress always still has that power, right? The delegations are always like temporary, right? Any legislative or quasi-legislative action taken by the executive branch can be reversed by Congress, right? So 2 justices are saying Congress still has the power, but to make a workable government in the 20th and 21st centuries, Congress is clearly free to do this. The other, I guess I'll leave Clarence Thomas out, so the other 6 justices in the trucking case are saying, well, yeah, we want a workable government. We want to make this work so Congress can delegate to the experts and make the government actually work and function the way it has been for decades. But we still think there's a key constitutional principle here about making sure Congress doesn't give away its legislative authority. So we still are going to look, anytime somebody challenges it, we're going to look and make sure did Congress clearly set an intelligible principle that the regulators can follow. If Congress didn't give any guidance at all, then that would violate, the principle's still there, and that would violate it, right? So 2 justices are saying, get rid of the principle, let Congress delegate as much as it wants, which isn't as crazy as it sounds when I say it like that, because Congress still has the power to step back in whenever it wants. 6 justices are saying, well, we're going to be flexible, make this workable, but Congress does have to make sure it gives an intelligible principle to the regulators. And then Thomas is saying the same thing, plus I also think maybe we should reconsider these holdings and maybe move back to a stricter version, right? I mean, it's a brief concurring opinion. He doesn't say a lot in there, but he says we should maybe move back to a stricter version of this. And so it is an example of a technical constitutional doctrine, right, that is not anybody's front page news, but that potentially has very significant policy and political consequences. In the hands of a court that wanted to do this, right, this doctrine could be revived in such a way as to invalidate, like, every federal regulatory statute enacted since the 1930s, right? All of them are inconsistent with the way the federal government was understood to work before the 1930s, right? The whole scope of the federal government changed dramatically in the 1930s, with some precursors before that, But so, like, in the hands of a court that wanted to, they could use this to strike down an awful lot of laws. We have no idea if the court will go down that road, and it would be politically controversial if they did go down that road, and people would push back, and they might back down, right? So, but that is a potential significance of this kind of case. So this lecture, so I might have to change this lecture next year, depending on what they do in Gundy. But the way I've been talking about these cases since 2001 is like this, right? So this is how they used to do it back in the 1930s, right? Somebody, the lawyers for the American Trucking Association, tried to persuade the court to go back to that in 2001 and failed, right, unanimously. The court is not interested in going back to the way we did that in the 1930s. And so in the modern version of our federal government, right, which is very different from the original 18th century version, right, in the modern version of our federal government, Congress clearly does have a fair amount of leeway, maybe not complete leeway, but a fair amount of leeway to delegate some of its legislative authority to various other governmental agencies, right? Usually the straightforward examples are things like the EPA, right, where it's a particular federal agency whose name tells you what its basic function is, and there's like 1 or 2 main laws, like the Clean Air Act and the Clean Water Act are the main ones, right, that lay out the general principle, and then that agency is charged with issuing regulations in pursuit of that principle. And so that's the general constitutional framework that is clearly in place at the moment. And so then the next thing to think about is, well, if that is the case, right, if that is how most regulatory law is crafted in our current constitutional system, and the Supreme Court is okay with that, if that is the case, then there's a whole bunch of sort of subsequent questions that come up. Well, okay, so the Congress is allowed to delegate some aspect of legislative authority to executive branch agencies. so can Congress do it like this? And can the president respond like this? And is the agency allowed to do this or not allowed to do this? There's a whole bunch of subsequent cases that come up, right? So all of this could potentially change next year, depending what they say in Gundy. But for now, assume that Congress is in fact allowed to delegate some degree of legislative authority to the executive branch, right? Not give it away permanently, right? Not give the executive branch authority to do anything it wants, but delegate some degree of legislative authority. So here are some subsequent questions that come up, right? One question that comes up is when Congress has delegated legislative authority to an executive branch agency, is that agency required to exercise the authority that has been delegated? Now, presumably the agency has some choice amongst various options, right? Otherwise, what would it mean for Congress to be delegating something to the agency, right? If the Clean Air Act says the EPA is charged with setting ambient air standards for various pollutants at the level requisite to protect the public health, then in any given case, right, should the standard for mercury, in the water or in the air be 10 parts per million or 100 parts per million? What should the legal standard be for how much you're allowed to dump into a stream, right? The EPA has that choice. But what if EPA declined to issue any regulation at all, right? It's not that they were, right, like they clearly have some degree of choice about what kind of regulation to issue, but what if they declined to exercise the authority at all? That is basically what happens in the case called Massachusetts versus EPA, which is in 2007. And it's a case about global climate change, which is not something the Supreme Court has weighed in on very often, but it gets drawn into the issue on this case. It's again about the Clean Air Act, which again says that the EPA is required to regulate the emission of all air pollutants. So this is a specific provision of the Clean Air Act. The EPA is required to regulate the emission of all air pollutants by motor vehicles that may reasonably be anticipated to endanger the public health. Right? So anything emitted by a car into the air that may reasonably be anticipated to endanger the public health, the EPA is supposed to regulate it. And again, the details should be figured out by the experts at the EPA, like what should be the specific emission standard that applies to different kinds of cars. That should be figured out by the EPA, right? When the Clean Air Act was enacted in the early 70s, nobody knew anything about global climate change, right? We knew some things about air pollution that was harmful to public health. There were some U.S. cities, Los Angeles in particular, in which there was so much smog. Like, I visited Los Angeles as a kid, and I remember in the 70s, like, there were mountains that were supposed to be visible from Los Angeles because they were not that far away, and you just could not see them because the air was so thick with smog because of so much driving in and around L.A. And so the Clean Air Act was designed to try to reduce that form of air pollution, but it was not designed to try to address global climate change because nobody knew about global climate change yet. But in the late 1990s, environmental organizations started petitioning the EPA to regulate the emission of carbon dioxide and several other greenhouse gases that are major contributors to global climate change. Right? Carbon dioxide gets trapped in the atmosphere, and it prevents heat from escaping from the planet out into space, right? So it contributes to the rise in global temperatures, right? And more cars on the road in more and more places throughout the world without regulation are increasing, not just cars, but cars are one of the main contributors, are increasing the amount of carbon dioxide in the atmosphere and so increasing global temperatures. And in 2003, during the George W. Bush administration, the EPA said no, right? So environmental organizations petitioned the EPA. They said, here is something that is being emitted by motor vehicles into the atmosphere that is harmful to human health because global climate change is harmful to human health. And the EPA has not yet regulated it. We are petitioning the EPA to regulate the emission of carbon dioxide by motor vehicles. It's going to be up to EPA to decide what the specific regulations should be, what level is allowed, but EPA should issue a regulation. EPA said, no, we're not going to issue any regulation of carbon dioxide. We don't believe that carbon dioxide is covered by the Clean Air Act. It has never been regulated previously under the Clean Air Act. Carbon dioxide itself is not harmful to human health. It is part of the air that we breathe. Right? We don't think it counts as a pollutant that is supposed to be regulated under this act. And the environmental organizations went to court, and they made their way to the Supreme Court, and they won. And the Supreme Court said, based on the text of the Clean Air Act, which says the EPA must regulate the emission of all air pollutants by motor vehicles that may reasonably be anticipated to endanger the public health, carbon dioxide clearly fits, right? It is emitted by motor vehicles into the air, and it may reasonably be anticipated to endanger public health because global climate change is going to lead to all kinds of mass chaos and death and disease and superstorms and the like and flooding. And so the Supreme Court ordered the EPA to issue a regulation. It's still up to the EPA to decide what the regulation should be, right? What levels of carbon dioxide are cars allowed to emit? That is for the scientists at EPA to decide. But they cannot refuse to issue a regulation that is mandated by the text of the Clean Air Act. Bush administration dragged its feet for several years until George Bush was no longer president, and then when Obama came into office, the EPA issued those regulations. A variety of corporate polluters challenged those regulations in court, and for the most part, they have still never yet taken effect. Some of them have taken effect, but some provisions remain tied up in court. So that's one question, right? And the political context, in your lifetimes, like recent decades, the political context for all of these disputes is frequent situations of divided government, right? Where if Congress is controlled by one party and the executive branch is controlled by the other party in either direction, right, then you are going to have situations where Congress thinks something should be regulated and an executive branch agency thinks it shouldn't be, or vice versa, right? And one of the big sort of background questions to keep in mind, or maybe this is one question to keep in mind for all of these disputes, is if you have a dispute between Congress and the executive branch, right, that is in part a constitutional dispute, right? Partly it's a policy dispute. What do we think the best environmental rules are? That's a policy dispute. But partly it's a constitutional dispute because somebody is arguing that it is unconstitutional for an executive agency to refuse to exercise the authority that Congress has instructed it to exercise, right? If there's a constitutional dispute like that between the legislative and executive branches, there are at least two ways that we might think of to settle that constitutional dispute. Option one is we let Congress and the President figure it out, right? They got checks and balances. They each have authority to influence the actions of each other. Congress can hold hearings. They can call in the director of the EPA and force him to testify on television in front of the relevant congressional committee and explain why he is refusing to regulate carbon dioxide. And he can give his arguments, right? They can push back against each other. And when government is functioning well, right, they will reach some kind of compromise agreements and they will figure out a workable set of regulations that Congress can live with and that the executive branch can live with. That is one way to settle disputes of authority between the legislative and executive branch. Another way to settle them is to go to court, right? If somebody is convinced that one side of this dispute is being so intransigent and is basically violating their constitutional duties, right, then you can try to persuade the federal courts to step in. And the federal courts are not going to figure out all the details of environmental policy, right, but they can order one or both sides to take certain actions, right? And that's what happens in Massachusetts versus EPA. And the upside of judicial intervention, right, is that if the two branches are just completely at odds with each other and not doing anything, like the court can force something to happen, right? The court can't figure everything out, but it can force something to happen. So that's a potential upside in some situations. The downside is the judges might come up with institutional solutions that are not perfect. I mean, the existing stalemate is not perfect either, but the justices might impose. The justice tendency is going to be to look backwards at the Constitution, right, and figure out, well, how is this supposed to work? And they might have, compared to the legislative and executive branches, the judges might have a tendency to impose legalistic solutions that have pragmatic problems of workability in the real world, which is how many people would describe this, right? The Supreme Court was imposing this in the 1930s for good constitutional reasons, but they imposed it in ways that prevented the government from addressing important public problems. And that is one of the key reasons why the court stopped imposing it and basically said, okay, Congress and the President can work this out on their own. Okay? So one question. So if Congress is allowed to delegate some degree of legislative authority to the executive branch, one question is the executive branch required to exercise that authority? Supreme Court said yes in the Massachusetts case. Another question that comes up is, assuming that Congress can delegate some degree of authority to the executive branch, what kind of procedures is Congress allowed to, I guess I want to say, invent? Can Congress invent novel procedures in order to ensure that when we delegate authority to some executive branch agency, Congress is still maintaining ultimate control? Right? We know that Congress could always pass a new law. Right? So if Congress passes the Clean Air Act and says the EPA is supposed to do this, and then if EPA is not doing that the way that we meant them to do it, Congress can always pass a revision to the Clean Air Act. But passing a new law is hard, and one of the reasons it is hard is because the President has to agree. Right? You got to pass both houses of Congress, and then the President's got to sign it. And if we are talking about a situation where we have a dispute between the legislative and executive branches, why is the President going to support Congress's new law, right, to try to get Congress's side back on top? Right? So can Congress come up with other novel procedures to try to ensure that even though we are temporarily delegating legislative authority to this part of the executive branch, it's Congress's rules that should ultimately hold sway? And here's an example. Congress invented a procedure which it called a legislative veto, which is not really a thing, right? In the Constitution, it is not a thing, right? Congress votes for a law, and then the President gets to veto it if he wants, right? There's no such thing as a legislative veto. But here's what Congress meant, and I'll illustrate it with a case called INS versus Chadha. So INS, this is from the 80s, and at the time, the federal immigration agency was called the Immigration and Naturalization Service, which was INS. It was before the Department of Homeland Security, etc. There's no ICE, different acronym. So a guy from India named Jagdish Chadha came to the United States in 1966 on a student visa, which expired, which meant he was no longer lawfully a resident of the United States. He was now an undocumented immigrant. And it expired, and he stayed in the United States. And he came to the attention of immigration authorities at some point, and was scheduled for deportation. And the immigration laws at the time had a provision that said, right, any undocumented immigrant who is in federal custody and scheduled for deportation can be exempted from deportation on the authority of the Attorney General. right? So here's some broad categories that apply to different kinds of immigrants. Here's people who would be subject to deportation, but in individual cases, the Attorney General of the United States can cancel the deportation and give somebody a visa, right, as a lawful permanent resident alien, right, allows them to stay legally in the United States, right? So broad categories of people, undocumented immigrants who are subject to deportation. The Attorney General is allowed to exempt people from that, right, in particular cases where he thinks it's merited, right? Think about the Dreamers, right, for a contemporary example, right? Somebody decides that a certain set of people who are undocumented immigrants and hence legally subject to deportation should not be deported because, for whatever humanitarian grounds, we think they deserve to stay. And so the Attorney General exempted Mr. Chadha from deportation. But the law also said that any time the Attorney General exempted anybody from deportation, he had to send a list of those people to Congress. And Congress could vote. In fact, a single house of Congress could vote to veto the Attorney General's exemption from deportation, hence the phrase legislative veto. So the law says this category of immigrants is subject to deportation, but the Attorney General can exempt them. The Attorney General exempts this guy, but then he has to send a list of the names to Congress, and the House of Representatives votes, in Chadha's case and with 5 other immigrants, 6 people, votes to deport them after all, right, to veto the Attorney General's exemption. And Chadha and his lawyer go to court, and they make their way to the Supreme Court, and they win. And they say Congress is not allowed to exercise a legislative veto of the actions of an executive branch agency in this fashion. And from one angle, this decision makes tons of sense. Right? And here's what the court says. They look at the text of the Constitution. They look in particular at Article 1, Section 7, which is the how a bill becomes a law part. Right? And 2 of the requirements that you see in Article 1, Section 7 2 of the requirements in Article 1, Section 7 for how a bill becomes a law are bicameralism and presentment, which is lawyer way of saying both houses of Congress have to vote for the law. That is what it says. You are familiar with the Schoolhouse Rock, I Am Just a Bill song, right? Both houses of Congress got to vote for you to become a law, and it then has to be presented to the president for his signature. And he can either sign it or veto it. And if he vetoes it, it goes back to Congress, and both houses can still pass it if they get 2/3 in each house. Right? This legislative veto didn't follow either of those requirements. Right? A single house of Congress voted to deport these 6 people. And now they are now subject to deportation. I mean, the original law passed up, met these requirements, right? The immigration law that spelled out these procedures was passed by both houses and signed by the president. But this particular legislative action, subjecting 6 named individuals to deportation, was passed by one house and not presented to the president. And the Supreme Court says that's unconstitutional. There's another case some years later, during the Clinton era. It's called New York versus Clinton versus New York. Clinton versus New York, where the court basically says something similar. That case, Congress had passed a law authorizing the president to exercise a line item veto. Right? So, of course, Article 1, Section 7 says the president's allowed to veto a law. One of the problems with how that functions in the modern state, right, is that Congress passes giant, omnibus budget measures that include, hundreds of pages of government spending authorizations. And that's what they present to the president, and they're like, sign it or veto it. If you veto it, the government shuts down, right? If you sign it, your side, the president is agreeing to all these expenditures that he doesn't actually support, right? And so presidents had long asked for, and Congress finally granted, well, okay, in federal budget bills, the president's allowed to veto specific items. And the Supreme Court struck that down, right? That is not consistent with these principles, right? These principles say Congress passes the law, both houses, puts it on the president's desk, and he either signs it or vetoes it. It doesn't say nothing in Article 1, Section 7 about a president can veto part of a law if he wants to, right? From one angle, those decisions make total sense. Seems like it's inconsistent with the text of the Constitution. But both of these cases are divided, and they are not really divided on ideological lines, right? If you look at the justices in the majority and the justices in dissent, it is not like liberals versus conservatives or vice versa. They are divided on the lines of some justices believe very strongly that the court should try to stick as much as it can to the literal words of the original Constitution. And some justices believe very strongly that the court has to adopt a more flexible, pragmatic approach. And so in INS versus Chadha, the immigration case, Chief Justice Berger writes the majority opinion, Justice White writes a dissenting opinion. They are both relatively conservative judges. Nowadays they would both be moderate conservative judges. They often agreed with each other, right? They both dissented in abortion cases at the very time that INS versus Chadha was happening. They were both regular dissenters in abortion cases. And White thinks that the decision in this case is crazy and is going to have harmful consequences. From his perspective, here's the way to think about it, from White's perspective. Over the course of several decades, we have abandoned this principle, right? We don't strictly enforce the non-delegation doctrine anymore. We allow the legislative branch to delegate some degree of authority to the executive branch. That is what Congress did here, right? They delegated some degree of authority to the Attorney General. And all that they are trying to do is make sure that the delegate exercises the authority in a way that is consistent with the views of the branch that delegated it, right? It's Congress's power. Congress can deport us, say everybody's subject to deportation, or nobody is, if they want, right? Congress gets to write the immigration laws, right? And all they're trying to do is say, oh, well, to make it workable, we're delegating some discretion to the Attorney General, but if he exercises his discretion in ways that we did not intend, then we reserve the right to weigh back in. That seems like a workable compromise between the two branches. It is not like one branch usurping something from the other branch. Right? The point of the separation of powers is to make it harder for governmental tyranny to develop, right, by dividing power up. And the court has to keep an eye to make sure one branch isn't trying to usurp all the powers to itself. That is not what's going on here. It is a workable compromise that involves both branches in the decision-making, but leaves the ultimate authority to decide on our immigration laws with Congress where it's supposed to be. There is nothing wrong with that. White also pointed out that there were hundreds of federal statutes that included similar provisions. Right? They weren't all identical, right? Congress had done it in a variety of different ways, but there were tons of modern laws in which Congress had delegated some authority, but then added on this procedure, like, oh, but if they exercise in a way we don't like, then here's how we can weigh in. Sometimes they said one house could do it. Sometimes they said it had to be a concurrent resolution of both houses, but didn't have to be presented by the president. Right? The specific details were different in different laws, but there were tons and tons of laws that were enacted by Congress and signed by the president. Right? The immigration law was signed by a president. Right? There were tons of federal laws that had been enacted by Congress and signed by the president that included these kinds of novel procedures. And there's no way that we should try to impose some like strict legal limit that prevents Congress from doing this ever again. Does that divide make sense? Right? So Berger's like strict, literal words of the constitutional text, only one way to pass a law. White is like more flexible, more pragmatic approach. We need to impose constitutional rules that allow the government to function in a workable manner. We're just supposed to make sure no one branch is trying to usurp all the powers to itself. That is clearly not happening here. Nothing wrong with this. Right? To give you just a couple other quick examples of situations in which Congress has tried to come up with novel lawmaking procedures. There's a major debate in the 80s about criminal sentencing, right? And there's a major tightening of federal criminal sentencing in the 1980s. Conservatives at the time tended to argue that federal criminal sentences were too lenient, and many liberals argued at the time that federal criminal sentences were too disparate, right? That judges had such wide discretion in terms of what they were how they were going to sentence you. So you get convicted of, first-degree murder under this judge, and you get this sentence, and then you get just convicted under first-degree murder of this judge, and you get a much harsher sentence, or whatever, right? So there was widespread support for reforming the system of federal sentencing, and what they came up with was a federal law enacted under Reagan that created a new detailed set of said that our goal was to have a new detailed set of federal sentencing guidelines. But we in Congress are not going to work out all the specific details of what those guidelines are. We are instead going to delegate that to a federal sentencing commission, which is going to be a new bipartisan commission, which will include 3 federal judges plus 4 other members appointed by the President or Congress, whatever the rules were. And this 7-person commission will be charged with coming up with a set of sentencing guidelines, basically a grid, right, that judges could look at, like what's the crime, how many priors, what other relevant factors are there, and you could put that information on a grid, and it would give you a range, a mandatory sentencing range that the judge was then supposed to follow. So sentences are going to be tougher, and they're going to be more equal throughout the country. It's not going to depend as much which judge you get. John Mistretta was sentenced on a drug charge, and he got a high sentence under this guideline range, and he challenged this whole system as unconstitutional, said it was an unconstitutional delegation of legislative authority to this sentencing commission. Right? How many years in prison are you subjected to for cocaine trafficking is a legislative decision that should be made by Congress. And he lost 8-1 in the Supreme Court. And the way this was in 1989, and the way this case was usually interpreted at the time is the court has backed away from its strict formalist approach to the separation of powers in the immigration legislative veto case. Right? In that case, the court seemed to be trying to strictly say Congress is not allowed to come up with any of these novel procedures. In this case, the court goes the other way. And they say, okay, we see an important public problem. Congress wants to address it. It is reasonable for Congress to conclude that they can't figure out all of the specific details of federal sentencing ranges by themselves. So they delegate the authority to work out those details to a commission of experts. Congress still has all the relevant power. Anytime it wants, Congress can pass a new law saying that minimum sentence for cocaine trafficking is higher. We think that Sentencing Commission set it too low. Congress can change it anytime it wants. They are free to delegate the authority to this commission. It's 8-1. Scalia is the only justice in dissent. And Scalia makes the same kind of argument that Berger made in the legislative veto case. He's like, not consistent with the text of the Constitution. Can't do it this way. I don't care if it makes things more complicated, right? you're not allowed to do it this way. But all of the other justices are like, nope, we want to give some leeway, some practical leeway for Congress and the president to work things out. A very similar debate. Yeah, Colin?
Didn't they already decide that in like Caroline Products? Like sort of that they were going to delegate more to like experts rather than like Congress had the ability to delegate to experts?
I don't think that's the exact issue in Caroline Products. I mean, the court, one of the things the court says in that case, so this is back in 1938, one of the things the court says in that case is that just in general, the court, are going to defer more to the legislature, right? And part of the reason that they give for that is that the legislature has more expertise than we do, right? It was a regulation of sale of milk products, right? And Congress had held hearings and brought experts in to testify about what kinds of milk products were safe and what kind of milk products were being adulterated with what kind of substances and that shouldn't be sold and the like. And Congress had come up with a set of regulations. And so the court is saying, yeah, Congress is more expert than us. We're going to defer to them. And so then these cases are sort of about a related but slightly distinct issue where Congress might be holding hearings, they might be hearing from experts and considering, but then they are saying, we're not going to try to work out all the details ourselves. We are going to create a milk board, right, staffed with experts, and we're going to delegate to them the authority to figure out what the specific milk rules should be. That's what's going on here. There's a very similar debate right around the same time about the independent counsel law, which we talked about last time. Remember, after Watergate, people are like, oh, what the heck should we do if there's credible allegations of criminal activity by the president or some other high-ranking executive branch official? Ordinarily, federal crimes are investigated by federal prosecutors. But federal prosecutors all report to the Attorney General, and the Attorney General reports to the President, so it is a little tricky to figure out how those folks can conduct a credible investigation of the President. Right? And so Congress passed a law in 1978 which set up these complicated procedures. You got to go to the Attorney General first, present credible evidence, right? The Attorney General can trigger the investigation. Then a panel of 3 life-tenured federal judges whom the Attorney General doesn't get to choose, right? The Chief Justice chooses them. They pick an independent counsel, right? They appoint a distinguished and highly qualified lawyer to conduct the investigation, and then he or she then has their own separate budget, and they're not subject to oversight by the Attorney General or the President anymore. That gets challenged as unconstitutional because it is a kind of novel procedure intermingling legislative and executive powers and judicial powers. Ordinarily, the decision to prosecute somebody for a crime is part of executive power. So ordinarily, everybody who is a federal prosecutor ultimately reports to the president because they are part of the executive branch. Congress is creating a new kind of prosecutor that does not report to the president for the obvious reason that we want somebody to be able to investigate criminal activity by the president. We don't want him to report to the president. Right? Congress is attempting to address an important public problem by coming up with some novel institutional setup. Scalia says it's unconstitutional. You can't do it. Is the guy exercising prosecutorial authority under the authority of the U.S. government? Then he is part of the executive power, and he reports to the president. There is no other constitutional way to do it. But that decision is also 8-1. Right? It's called Morrison versus Olson, and the Supreme Court upholds the independent counsel law, 8-1. They're like, we can't. We have tried various times in the past to impose really strict limits on what Congress is allowed to do and what the president's allowed to do. It doesn't work. To have a workable government that allows Congress to respond to important national problems, you got to give some flexible leeway. Right? Congress is not usurping all the powers to itself here. Congress is not trying to take full control over federal prosecutorial decisions from the executive branch. It is one narrowly crafted exception to the ordinary rule of how federal prosecutors will operate. And it is for the very good reason of trying to come up with a credible way to investigate alleged criminal activity in the White House, which we have recent experience to tell us is necessary, right? They're referring back to Watergate.
So is it inherently easier for Congress to delegate powers when there's obviously just unified party involved?
Yeah, but it's tricky, right? So like when the Clean Air Act is passed in the early 70s, it's actually first passed under Nixon, but Nixon was reasonably supportive of environmental regulation, right? And so Congress is not anticipating, when they pass that law, they're not anticipating sharp conflicts between Congress and the EPA. They're saying, we all agree, we got too much pollution, we're trying to solve it, right? It's like a policy response. It's not like a polarized partisan issue in the early 70s. But then over time, like the EPA under the Reagan administration and then the EPA under the George W. Bush administration gets accused of failing to execute the authorities that it's supposed to exercise under that law. And then now, during some periods of time, you have a Democratic Congress and a Republican EPA, and they're at odds with each other. So there's short-term considerations, and there's longer-term considerations. Like right now, any law that Congress passes, they know is going to be enforced by the Trump administration, right? And presumably they might have broad agreement about many policy issues that they're trying to address, although maybe not trade, right? But on some issues, they might have broad agreement, right? But Congress also knows, right? Paul Ryan also knows that Trump might not be in charge forever, right? And so that if they pass a law 4 years from now, it might be enforced by a Democratic administration, right? So, like the line item veto case, the line item veto was something that Republican presidents had been demanding for years. Reagan and the first President Bush had both demanded it. But Democrats were always in control of Congress, and they didn't want to do it. They wanted Congress to still have full control over the budget. In the 90s, Clinton was president, and there were Republican majorities in Congress, and the Republicans enacted a line item veto law. Even though they were given that authority to a Democratic president, they were like, yeah, but we'll have some Republican presidents again, and we really want them to have this authority. We think this is a better way to do it. So they were willing to enact that, even though the immediate result is they were giving more power to a Democratic president. So a little bit of time left. So let me say a couple more quick things. So one concept that comes up repeatedly in these debates, we'll talk about this a little bit more after spring break too, but I just want to flag it, is the lawyers and judges sometimes talk about a concept of the unitary executive, right? Scalia talked about this in his dissent in the independent counsel case. The first sentence of Article 2 of the Constitution says, the executive power of the United States shall be vested in a president. Right? On Scalia's reading, anything that is included within the concept of executive power, whatever those two words mean, belongs to the president. Right? It says, clear as day, the executive power shall be vested in a president. Right? And so if prosecuting someone is part of executive power, then that belongs to the president. Obviously, the president can't do it all by himself, right? He has to have prosecutors who work for him to help, right? He can't do it all by himself. But the authority ultimately remains with the president, right? And so it is unconstitutional for Congress to try to take some executive authority away from the president and give it to somebody else. And the shorthand phrase for that line of thinking is the unitary executive. The executive branch is unitary. Ultimately, all the authority lies with one person, which is not true of the legislative branch, right? There's no one person who holds all the legislative authority, right? But there is one person on this reading of Article 2. There is one person who holds all the executive authority. That's a concept that comes up a number of times during the post-9/11 debates about executive power that we'll look at after spring break. So I wanted to flag that. Let me say a quick word about the impeachment of Bill Clinton. We're talking about conflicts between the legislative and executive branches, and like the ultimate resolution of such conflicts is that Congress has the authority to impeach the president. During Bill Clinton's term in office, a independent counsel was appointed. His name was Ken Starr. He was appointed to investigate some shady real estate dealings by Bill and Hillary Clinton, allegedly shady real estate dealings by Bill and Hillary Clinton during their time in Arkansas, right? Things that had happened before he was president. Meanwhile, Paula Jones who had worked for the government of Arkansas while Bill Clinton was governor of Arkansas, had filed a sexual harassment lawsuit against Bill Clinton. Again, it was for allegations about things that had happened before he was president. And the Supreme Court heard a case called Clinton versus Jones, in which the Clinton administration tried to argue, in some ways similar to what Nixon's lawyers had argued in the Watergate case. Clinton administration argued that the president could not be sued while he was president. Right? If somebody files a suit against the sitting president of the United States, you just got to put that thing on hold until he's no longer president. There is no way for a president to exercise the momentous authority of the presidency if he's subject to responding to constant lawsuits. Right? If the president did something that violates that like abuses his power, he can be impeached by Congress. That's the thing that's in the Constitution for addressing misconduct by the president. And once he's no longer president, then of course he's an ordinary citizen and anybody could sue him. Clinton's lawyers make that argument and they lose in the Supreme Court. The Supreme Court says the Paula Jones suit can go forward. In a famous line that scholars like to make fun of, the court said, the president's lawyers argue that this is going to completely prevent him from performing the functions of the presidency. We don't see any significant evidence that this is going to impose any significant burdens on the president's performance of his duties. We trust that the federal judge in charge of the case will keep a good handle on it and will be sensitive to the president's schedule and other commitments and things like that. And it was so that's what they said. It turned out to be wrong, I guess, right? I mean, the Paula Jones suit kind of ballooned into the Monica Lewinsky investigation and almost brought the presidency crumbling down, right? So Paula Jones's lawyers uncover multiple other women who have alleged either sexual harassment or assault, some of them on the part of Bill Clinton, or others just allegedly had been involved in extramarital affairs with Bill Clinton. And Jones's lawyers start collecting evidence on those other women's cases to support their own case. And then they send all of that evidence to independent counsel Ken Starr, and he decides to expand the scope of his investigation. And one of the things about the independent counsel law is it is a prosecutor who does not report to anybody else, who has his own independent budget, who has a fairly substantial amount of leeway to follow the investigation wherever he thinks it might lead. And so Ken Starr investigates the Monica Lewinsky affair, gets Bill Clinton to testify under oath that he did not have sex with Monica Lewinsky, which turned out to be a lie, and he gets impeached for perjury, for lying under oath, and for obstruction of justice, right, for attempting to influence witnesses, right, persuade them to lie and whatever, obstruct the investigation. Bill Clinton gets impeached, but not convicted and removed. The big debate during the Clinton, the big constitutional debate during the Clinton impeachment is what counts as a high crime and misdemeanor, right? The Constitution says the president can be impeached for treason, bribery, or other high crimes and misdemeanors. No evidence that Bill Clinton engaged in treason or bribery. So what counts as a high crime or misdemeanor? An extramarital affair probably does not count, but trying to influence witnesses to lie to a federal investigation about an extramarital affair, that might count, right? Obstruction of justice is illegal, right? So that was the big debate at the time. Last thing I want to say. Everything we've been talking about today is about just more or less good faith, legitimate legal disagreements between Congress and the presidency about who's allowed to do what in what situations, and there's good lawyers' arguments on both sides. As we know from last class, right, there are some disputes between the president, some disputes about the presidency that are in another category, right, where if you are hiring criminal burglars to break into the opposition party headquarters, that is blatantly illegal activity, right, that no legitimate reading of the proper scopes of presidential power allows him to do that, right? Obstruction of justice is probably in that category, right? Lots of the things that are in front page news at the moment, if they happened, are in that category. right? Conspiring with agents of a foreign government to influence American elections is clearly unlawful, right? Using campaign funds as hush money to pay off somebody with whom you've had an extramarital affair is clearly unlawful, right? Hiring family members to work in the federal government is clearly unlawful, right? Using federal government events to enrich your own private business is clearly unlawful, right? Lots of the things that are currently being investigated are not just ordinary disputes about the proper limits of presidential power. They are allegations of actual illegal activity. And if those things are proved, then we're like back in the situation that we were in Watergate or Bill Clinton, right? But worse, maybe. So let's keep an eye on that.